All right, and Mr. Fragel, we have up next, people of the state of Michigan versus Cade McGregor.
Good afternoon, Your Honor.
Look at that, we're only 15 minutes behind from when your case was on the docket. So I don't feel too bad about that. All right, this is file 24-6952FH. Counsel, you want to state your appearances beginning with people?
Melissa Goodrich, Wayne County Prosecutor.
Patrick Fragel on behalf of Cade Campbell McGregor.
All right, and we're here for a docket call, and also the defense has filed a motion to quash based upon the corpus delicti rule. Mr. Fragel, go ahead and argue your motion, sir.
So you may argue from the podium, Your Honor?
That's fine, or from table, whichever you prefer is fine with me.
No, the facts in this case are relevant in that the victim visited the defendant's home early in the morning. The parties tend to agree that she had been drinking. The extent of the intoxication is unknown. And there was, they woke up the next day, spent the day together, went to the beach, saw his sister, saw his child, came back later that evening. And it was then disclosed to the victim that they had had they had had sex, oral, vaginal, and anal. There was no statement that it was non-consensual, and it was left at that. The district court dismissed count one, the life offense, because there is no evidence of physical injury. There's no evidence of a sexual assault beyond the defendant's statement to the victim that they had relations the evening before. And the district, it's important to point out that count one was dismissed because lack of evidence of physical injury. Because that same logic applies. There's lack of evidence of any type of sexual assault in this case, other than a statement from the defendant. So I would carry that same logic to all three counts of CSC third that he was bound over on, that there was no evidence on the essential elements of penetration. The district court's finding, page 43, line 15 through 44, line 22, delineates that he's basing this bind over strictly on the defendant's statement. There's no evidence of any physical or sexual assault. Now, the corpus delicti rule announced in People v. McMahon is pretty clear. And I didn't find any case law contrary to it, nor was there any provided to me from the prosecuting attorney. And that rule is that the prosecuting attorney cannot introduce a confession or even a statement against party opponent under 804D until they have prima facie evidence of that primary element, in this case, a sexual penetration.
Can I ask you about that? I mean, I agree with you with regard to that a confession cannot be admitted unless there's independent evidence of the crime. And in this case, you make a good argument that there may not be. However, in People v. Washington in July of last year, the Michigan Supreme Court made a distinction between, and they based it on some previous cases dating all the way back to 1934, of the difference between a confession and a statement. So you said, so statements can't be admitted. And that's what I want to ask you about. That they said a confession is where you've admitted like guilt, but just a partial admission or some statement that you made, even if it's prejudicial to your interests, is not barred by the corpus delicti rule. What would be your response to that? Whether I should consider the statements that he made as partial admissions versus confessions?
Partial admissions versus a confession. Yes, I'm familiar with that. Familiar with Washington. I was kind of waiting for the prosecutor to throw it my way so I could rebut it. Okay. Because this is a complete confession. He confessed that while she was under the influence, he had anal, vaginal, and oral sex with her. Those are the elements of sexual assault against an incapacitated person. And it happened while it was at his home in Sheboygan County. That's a complete confession. And that's what Washington, I believe, if I remember correctly, where it makes a distinction. So if he said, well, we had some fun last night, and she left her wondering, or left an open-ended question as to what exactly he meant, that would be an inculpatory statement. But a statement as to she was able to reiterate the 3 sexual acts they had based only on his statement. And that statement is a complete confession.
Okay, thank you. Anything else you want me to know to understand your argument?
The order quashing the information is on the back of the motion.
Okay, thank you. I appreciate that.
Proposed
Mr.
order.
Rich, people's response?
Yes, Your Honor. I did not come across People versus Washington, but I did come across an unpublished People versus Petton, and was going to make the same
Yes.
the same argument that a voluntary statement to a victim is different than a confession to a police officer. At the time, if you look at the transcript on page 12 at the bottom, when she was explaining, starting at 10, that when he went to kiss her and she asked him if something happened, and he was like, yeah, we had sex, was her words. I think that was a statement to a victim, and it wasn't a confession, as Mr. Frigel is alluding to. Also, because she was intoxicated and couldn't recall the events of that night, as similar as what happens in date rape type cases without consent, because they're too heavily intoxicated and helpless. She did last recall in the transcript, she said, I remember falling asleep on the couch. And then she wakes up in his bed. Him trying to kiss her, him taking her to get the Plan B pill was showing that a sexual assault happened. He took her to the pharmacy to get that. I think all those things can be evidence used to show that a crime was committed, to later then admit his statements that sex did actually occur. Also after the preliminary examination, and not relevant to the motion to quash purposes, but later we do have DNA, which would cause the case then to just be refiled anyway with that evidence as well. Thank you.
Thank you. Any rebuttal argument, Mr. Frigel?
Yes, Your Honor. The Plan B is no evidence of a sexual assault, and that was obtained with the defendant and the victim together approximately 36 hours after they had relations, and at least 24 hours after she learned that they had had relations. That is not indicative of a sexual assault. But what it would be indicative of a sexual assault would be the same kit that she obtained about 36 to 42 hours after the assault. There's no evidence whatsoever introduced at the preliminary examination that there was a sexual assault, despite the same kit being prepared.
Your Honor, we had not received the results at the time of the prelim. Also, People versus McMahon is distinguishable here because that was a second-degree murder case. The victim had disappeared, and it wasn't until the defendant was interviewed 3 years later about a different murder that he had confessed.
All right, well, the corpus delicti rule is a very old rule that's designed to prevent convictions for people confessing to crimes without evidence that the crime that it actually occurred, because apparently even though it doesn't seem to make too much sense, this happens from time to time where people confess to crimes that never happened. So the rule has been in existence for a long time, and with an important pedigree, so to speak. But the Michigan Supreme Court has, back in 1934, People v. Porter, and then all the way up to 2024, People v. Washington. So for about 100 years, made a distinction between confessions and admissions. I must confess, I'm not sure I entirely see the distinction when you look at the purposes of the corpus delicti rule. I think it operates similarly, but nonetheless, we have to assess whether the statements here constitute a confession. And as Washington, quoting Porter, says that confessions amount to a confession of guilt. An admission is something that needs other facts to give them convicting force. In this case, upon close review of the preliminary examination transcript, the complaining witness says that upon awakening, and then she didn't recall what had happened, that I asked if anything happened. And then according to her testimony, then the defendant described that they had engaged in various sexual activities. But in nowhere of those statements was he saying, I had sex with you while you were unconscious or incapacitated. He just said we had sex. And he described the things that they did. And in fact, from the way that she's relaying what he said, he thought this was fine, that this was something that had been consensual. So given her, I mean, the prosecutor will have to prove that she was incapacitated. His statements do not establish that fact. So he wasn't confessing to a crime to her. He was just telling her what sexual activities they had engaged in as he saw it together. So I think that does squarely fit in the distinction outlined in Washington and Porter, and also it appears in the unpublished case cited by the people, that this was not a confession, but it was a partial admission. And so therefore, even though it's inculpatory, it can be admitted without other proof that a crime or a sexual assault had occurred. So therefore, the statement was it was not improper for the district court to consider that statement in determining whether there's probable cause. And with the statement, there certainly was sufficient probable cause. So the defense motion to quash the information is denied for those reasons. And then, Mr. Fragel, I imagine that you'll want this set for further docket call. It sounds like there may be additional evidence for the parties to discuss how that's going to work and look at your options of what you want to do at this point.
Yes, please.
I'll put on the docket call order that the defense motion to quash is denied, but Ms. Goodrich, if you would prefer a separate order for record keeping, you certainly can submit one. Why don't we come back, Mr. Fragel? We've got some wrinkles in the scheduling this spring, so I could have you come back just in a couple weeks on May 13th, or not until mid or late June. What's your preference?
May 13th is fine, Your Honor.
Okay. May 13th. Does morning or afternoon work better for you?
Afternoon, please.
Let's do May 13th at 3:20. And I appreciate you making the trip up to argue this motion, but for a docket call, then if you wish to zoom in, I'll certainly allow that. So I'll indicate that Zoom appearances are allowed. And if you and your client want to be here, of course, you're always welcome.
Okay, thank you.
Yes.